Welcome to Brodie's webinar. My name is Stephen Goldie and I'm the Head of Litigation at Brodie's, and today we're going to be presenting to you on how COVID is affecting access to courts, arbitrations and the conduct of hearings. We've got a great lineup for you today on different components of what's going on. We've got Tony Jones QC, and Tony will be speaking in relation to the court system in particular. Tony has been co-opted into the Law Society Working Group on Scottish Courts and Tribunal Services as they grapple with the issues that they're going through. Tony works quite closely with the next speaker, Jamie Reekie, in the solicitor advocacy team. So they are people that are in the courts room frequently. We're then going to move on to Jared Oyston, who is a partner. Jared became a partner on the 1st of May. Jared joined us some time ago from a Magic Circle firm down in London, and Jared specialises an expert in English litigation, as in conducting High Court litigation this year. And last but by no means least, we've got Iain Rutherford, who is a partner in our business disputes team, and Iain is also involved with the Law Society. Iain is on the obligations committee. So without any further ado, please do keep the questions coming in on the Q&A function. And I'm going to turn you over to Tony to kick off.
Good afternoon, everyone. Stephen said that I find myself in courtrooms quite frequently, well, perhaps less frequently than I'm used to. In fact, I think this is the longest period without stepping into a courtroom that I've ever had in my professional career. Professor Richard Susskind asked some time ago, 2019 in fact, when he launched his new book, are courts a place or a service? And that's quite a critical question in the current climate, because what we're talking about today is, of course, access to justice. And it was Lord Neuberger a number of years ago who gave 8 propositions of what access to justice means, and 2 of them are quite critical at the moment. You have to have an effective procedure to get a case before a court, an effective legal process to drive it through the courts. And of course, at the moment, the courts are grappling with practical issues that have made it difficult for them to do both of those. And what's at stake for the Scottish legal system and the Scottish courts is their credibility as a jurisdiction where you can be sure that you will have access to justice and get your disputes resolved. In a legal market that in Scotland's worth 1.2 billion and UK-wide 35 billion, that's quite a lot of commercial interest in there too. Now, as you may have seen on the 11th of May, the Court of Session issued further guidance on how it was going to deal with current difficulties. And that guidance runs, it says, until the 1st of June. And in case you weren't holding the date in mind, 28th of May is the date by which the Scottish Government has to review the current lockdown. But suffice to say, the courts cannot operate normally. So moving on to the next slide, let's talk about some of the general issues that have come about. Electronic signatures. The legislation provides for the use of electronic signatures, and if you're wondering what that was, it's something associated with an electronic document that performs a similar function to a manual signature. And in reality, what that means is people are using scanned signatures to sign documents submitted to the Court of Session. Any hearings in the Court of Session require to be remote hearings. And if they are conducted on video conferencing such as this, then it is expected that normal dress will be maintained. So for gentlemen, that's lounge suits, and the equivalent for ladies. As you may already know, gowns were dispensed with in all but the likes of proofs some time ago. So if it's procedural hearings and the like, no gowns are required. Remote monitoring of email addresses happen only in relation to those specified in the guidance note. So don't expect that you're going to get a reply from any of the normal email addresses the court uses. Use of electronic documents is a 30 megabyte limit on the court server. So if the document size is larger than that, it will not get there. The court guidance, as per the commercial court has been doing for some time, is if you're lodging inventories, only lodge the inventory and not the productions. There is a backlog, a considerable backlog of non-urgent business and motions, but the full extent of that is not known to us at the moment, and we may find out more about that in due course. So moving to talk about the next slide, which is cancelled business. Now, some of you may have had business cancelled that was due to call for a procedural debate or a proof. The email address you see there, keeper@scottcourts.gov.uk, is the email to get in contact with if you're inquiring about what's going to happen about those cancelled hearings. But the guidance note indicates that no fixing of dates can be done at present. Substantive hearings can't be any jury trials. They're only going to be remote hearings, and each case is dealt with on a case-by-case basis, but you'll be glad to know that fees are charged as normal. Let's talk about the inner house. It was provided with WebEx video conferencing equipment, so all the judges are sitting at home, clerks sitting in their homes, and they're connecting by WebEx, which is a Cisco system. There are no known plans to roll out that facility to other parts of the court, the outer house. In the inner house, it's the division clerks who coordinate hearings. The media and public are said to have the ability to get audio access to the hearings, but there's currently nothing publicly on the website about how you go about getting such access. And evidently, it's electronic bundles are required for hearings, and the clerks coordinate how those are prepared and submitted. So let's talk about the outer house. All by order hearings are cancelled. Any other hearings which are required will proceed by way of conference call, and indeed I had one last week where we managed to put through a merger deal permission before the commercial court in front of Lord Docherty, which worked reasonably well, but it is quite different from appearing in court. Hearings can proceed by way of written submission, and I would suggest that anything more complicated than something that's all agreed, you probably want to have a written submission to back up what you're going to say over the phone. And all documents, again, are to be submitted electronically. Things will change in the future as the courts move towards having a greater facility to deal with business, but that is a position as it stands now and until the 1st of June. I'll hand over now to Jamie Reekie, who is going to tell you about the Sheriff Courts.
Thanks, Tony. So yes, I'm going to discuss the position in the Sheriff Courts, where we see the majority of civil litigation in Scotland conducted. And we saw in the immediate aftermath of the lockdown announcement in March that the majority of civil hearings in the Sheriff Courts were either adjourned to specific dates well into later in the year, or hearings were simply cancelled and the cases were assisted or paused indefinitely. And we were told in that immediate aftermath that it was only urgent and necessary business that could be dealt with in the Sheriff Courts, and initially there was little or no guidance as to what we might expect the court to consider urgent and necessary. Since then, we've seen Sheriff Court business be consolidated to within 10 hub courts around the country. The other 29 Sheriff Courts remain closed, but with any business requiring to be progressed being done so from the associated hub. We do now have some more detailed advice as to what business might be accepted by the court in terms of new business and new applications, and also what existing business that's been put on hold might be restarted and progressed. Important to say, though, that when the new guidance was published at the end of April, the court service stressed that it wasn't a return to business as usual, but it remains a positive that the Sheriff Courts are open and that they are starting to progress more and more business. So, what new business and new applications can we expect to be accepted by the courts? The starting point remains that it's urgent and necessary business that the courts will deal with. And the guidance that we've received really just gives us a bit more of a steer as to what kinds of matters we can expect the court will accept or fall into that category. Now, the table on your screen here has been lifted almost directly from the Sheriff Court guidance documents. I'm not going to go through it line by line, but you'll see that in every section of that table, the word urgent appears. There still has to be some urgency attaching to new applications and new business that we want to put before the Sheriff Courts. In terms of a bit more substantive guidance as to what kinds of specific matters we can expect to be treated as necessary, we see there, for example, urgent child protection issues, urgent interim interdicts, urgent adults with incapacity orders, and interim antisocial behaviour orders are amongst those that are specifically mentioned. If you anticipate an application which is urgent but doesn't fall into any of those prescribed categories, then all is not lost. There is at the end there a catch-all provision. Any other application determined by the court to be urgent will be accepted. And the key there is going to be, of course, convincing the court that the application is indeed urgent. Perhaps, not surprisingly, there isn't much guidance as to what urgent means. Urgency is a subjective thing, and what is urgent in one case will be different to what is urgent in another case, depending on the context. And I suspect we may well find cases where the subjective views of parties, or at least one of the parties, as to what matters are urgent might not match up with those views of the court. So that's new business and new applications. We'll move on now to briefly consider what existing cases that have been put on hold might be restarted and progressed. I think we've got a slide we can move on to. Thank you. There is provision for certain categories of cases that have now been put on hold to be restarted, but it's only certain categories of case and only where certain conditions are met. So the categories of cases that can be restarted are those in the ordinary court, the family court, commercial actions, adults with incapacity applications, and corporate insolvency cases. Anything else not on that list can't be restarted at this time. And there's at least three fairly important omissions from that list. One is simple procedure, actions with a value of less than £5,000, usually debt recovery actions. They cannot be restarted at this time. Heritable actions, such as they still proceed in the Sheriff Court, mainly recovery of possession of public sector tenancies, they can't be restarted at this time. And neither can personal insolvency applications that have been put on hold. Certainly, in respect of those three categories, that looks like a policy decision not to allow those types of case to restart in the current financial climate. But if you have a case on hold that is in one of the categories that can be restarted, that's fine, but there's then 4 conditions to meet before the application will be accepted. And the 4 conditions are on the screen there. An important one is that there has to be good reason to restart the case. Unclear yet just how high a bar that is. Is it going to be sufficient that both parties agree the case should be progressed? Or are we going to need to see something more than that? And I suspect sheriffs will expect to see something slightly more than the parties are agreed. We can, though, presumably take it that the bar is something short of the matter being urgent, because if the application was urgent, it would fall within the categories we saw on the previous slide. Again, good reason is going to be a subjective thing, and even where parties agree that there's a good reason, it may not be the case that the court does. Another important point is that we're not yet at the stage where we're taking evidence remotely, and so the court has to be satisfied that the case can be progressed without the need for witnesses. If you think to meet those 4 categories or those 4 conditions, there's then a prescribed procedure to go through to make an application to the sheriff for the case to be restarted. The sheriff considers the papers and can then either allow the application or refuse it. Where the application is refused, the interlocutor has to give reasons for that refusal. So as to the conduct of remote hearings in the Sheriff Court, well, generally they're to take place by telephone conference. These aren't new things in the Sheriff Court. We've seen them in commercial actions for some time now, and the courts are well used to setting up and conducting telephone hearings. But excitingly, it doesn't look like we're going to stop there, and we saw some history made on Tuesday where the first substantive Sheriff Court hearing was conducted by video conference, notionally at Inverness Sheriff Court. And Brodie's were involved in that. Our colleague Craig Watt appeared as solicitor advocate in the debate, and the feedback from that hearing seems to be positive, with a collaborative approach between parties and the court, ensuring the hearing went quite smoothly. And we're going to have to see that kind of approach of cooperation between the court and parties going forward to ensure remote hearings continue to go smoothly. One final quick point on the Sheriff Appeal Court in terms of its existing business. As of this week, it was starting to programme procedural business. Its preferred approach is to deal with matters on the basis of written submissions, so just on the papers, but there is the option for a telephone conference where that is required. No detail as yet as to when substantive appeal hearings might resume. So I'm going to hand over now to Jared to discuss the position on the English courts.
Thanks, Jamie, and good afternoon, everyone. I'm now going to give a high-level overview of how the courts in England and Wales have been coping under the COVID-19 restrictions. Guided by the old legal maxim, justice delayed is justice denied, the courts in England and Wales have been seeking to ensure wherever possible that cases can continue to make progress. And the courts have been making good use of existing and newer technologies in order to achieve that goal. So, although, as we'll come on to, the courts have had considerable success in moving business online, what might be less well understood is just how much of the court network in England and Wales remains physically open. So, of the court centres in England and Wales, 159 remain physically open to the public, judges and staff, with appropriate social distancing measures in place. And those range from the Royal Courts of Justice in central London, all the way down the network to dozens of county court centres across the country. A further 116 court centres remain open to judges and staff, allowing them to continue their work in their usual workplace. And all of that means that only 76 court centres around England and Wales have been closed completely. So how are the courts handling business under lockdown? There's been a large amount of guidance issued by individual courts from around the network as to how exactly cases will be conducted. But in general, as in Scotland, the courts have been seeking to prioritise urgent matters. And in the guidance that has been issued in the High Court, urgent has been defined as any business that would be sufficiently urgent to warrant an out-of-hours application in normal times. Now, what would that mean? In the commercial sphere, it might mean applications for freezing injunctions, in which time is always of the essence. In the family context, it might mean applications relating to the welfare of children. And all of that business has been consolidated into those courts that remain physically open to the public. And it's generally only in those urgent cases that traditional in-person hearings will be considered. So, although from the outset the courts have prioritised remaining open for urgent business, the courts have also had what one judge has described as unexpected success in keeping other business moving along. And this has been due to a combination of existing technological progress prior to the onset of the lockdown, together with a willingness to embrace new approaches in the COVID-19 emergency. So as regards existing technology, the English courts had already made significant strides towards the electronic filing of documents. Many courts, including county courts, have long accepted the filing of documents by email. And perhaps more importantly, a large and growing number of courts allow for filing through what is a reasonably sophisticated online portal called CE File. And those courts include the Business and Property Courts and the Queen's Bench Division, which between them handle the majority of commercial litigation in England and Wales. And the adoption of that technology over recent years means that many filings are already routinely made online. And in the COVID-19 situation, that has the benefit of reducing the pressure on court buildings and staff. What has been perhaps more surprising has been the court's success in taking hearings online. To put this in some context, prior to the lockdown, video technology would be used only in truly exceptional circumstances. For example, even the fact that a witness might be based on the other side of the world would usually not in itself be sufficient grounds for the court to grant permission for that evidence to be given by video link. However, since the onset of the lockdown, courts at all levels of the system have embraced telephone and video hearings as standard. The High Court's already seen a number of fully virtual trials, with legal submissions and cross-examination conducted by video conference, with judges, lawyers and witnesses participating from wherever they are based during the lockdown. However, in seeking to deliver prompt justice to litigants, I think it's fair to say that an overly rigid approach to the conduct of hearings would risk being self-defeating, and therefore we've seen different levels of the court system showing different levels of flexibility to court users. So, for example, in the county courts, which tend to deal with a higher proportion of litigants in person, we've seen a greater degree of flexibility. So if, for example, a claimant feels that he or she will not be able properly to present their case over the telephone or in video conference, possibly due to a lack of access or familiarity with that technology, and therefore is willing to await the physical reopening of courts before they pursue their case, the interest of justice might well favour an adjournment. And we've seen considerable willingness on the part of county courts to adjourn hearings in those kinds of cases. By contrast, in the High Court, and particularly the more sophisticated branches, the court's been willing to take a more proactive and prescriptive approach. That's included strongly encouraging parties to hold virtual hearings, and indeed in some cases we have seen judges order that cases be held virtually, notwithstanding the opposition of one or more of the parties. And as a result of this, a judge in the Commercial Court has recently observed that, to her knowledge, only a small handful of hearings have been adjourned as a result of the lockdown. And that judge paid tribute to the speed with which judges, solicitors and advocates have adapted to the situation, for example, moving entire cases across to electronic bundling at very short notice. In addition to the adoption of new technology, we've also seen common sense amendments to procedural rules in England and Wales. So, for example, under the civil procedure rules, parties are ordinarily allowed to extend procedural time limits by up to 28 days by agreement without requiring the permission of the court. And under temporary amendment, that period has been doubled to 56 days. And that means that the parties have greater flexibility to extend deadlines by agreement, and it ensures that limited court resources are not wasted on dealing with uncontested applications for extensions of time. So, although it's not been without its challenges, the response of the courts in England and Wales has generally been seen as something of an unexpected success. One note of caution I would add, however, is that the success the courts have seen to date has largely been in dealing with current business, and in particular hearings that were already in the court's diary when we entered lockdown. What we do not know yet, and may not know for some time, is how the courts will fare in dealing with new cases and in scheduling new hearings as the lockdown continues over the coming months. Looking further into the future, it's to be hoped that the court's success in dealing with business during lockdown will facilitate a more general move towards virtual litigation where it's appropriate. So in particular, there do remain significant parts of the court system which have not yet fully adopted online filing, and the COVID-19 emergency surely ought to provide the impetus for them to complete that process. As regards hearings, it ought to be difficult to justify a return to the old normal in which in-person hearings were standard. Many hearings across the court system last a matter of minutes. So having barristers and solicitors make a round trip to court to attend those hearings in person is obviously inefficient in terms of time and cost, unless there is some compelling benefit from having all parties in the same room. And the speed and apparent ease with which judges and practitioners have embraced remote hearings would suggest that there isn't some additional compelling benefit, and that that inefficient approach ought to become a thing of the past. And I think a move towards online filing and virtual hearings also ought to have real benefit for litigants. So, for example, in the past, many parties to disputes may have felt compelled to instruct solicitors and barristers who are geographically close to the court that will handle the dispute, whereas a longer-term move towards virtual hearings ought to promote greater choice for litigants. Obviously, very happy to take any questions on the chat function, but for now, I'm going to hand over to Iain Rutherford, who's going to have a look at arbitration in the COVID-19 context.
Thanks, Jared. Quite a lot of parallels between the arbitration position and the English court's position, but I think the starting point with any ongoing arbitrations was that it was effectively business as usual, and the main reason for that is that those on the call who are involved in arbitration will be aware that generally procedural hearings and arbitrations are conducted via telephone calls. There's a lot of paper submissions. There's engagement with the arbitrator by email anyway. So the need for having a physical presence with all the parties there in a room really only arises once you get to trial evidential hearings. Everything else was already being dealt with remotely, in large part with only occasional in-person hearings, and that was generally only if insisted on by the parties and quite often dispensed with. So initially business as usual. I would have said in relation to evidential hearings, the primary market reaction to begin with was that there were discussions about looking to postpone evidential hearings or trials. And that did happen if there was agreement with the parties, but usually only for a fairly short period of time. As it became clearer that this was going to be a situation that was going to subsist for longer, quickly the conversation moved on to adapting and adopting e-trial solutions. And I think probably one of the most encouraging aspects of this that we saw was that, yes, there was an impetus from the parties to drive these hearings towards e-trial solutions to make sure that the hearings actually took place. Actually, a lot of the contact that we had from arbitrators was really making very clear to the parties that that was the expectation of the tribunal, of the arbitrator themselves, and actually being quite proactive on the arbitrator side and suggesting solutions and raising issues about platforms and potential ways of working. So a real push to make sure that these hearings did actually take place, and that was happening within, a matter of weeks. So a positive step there, and showing that real kind of impetus that's there in an arbitration to push through to a conclusion. So with that being the case, I think what I'd like to move on to speak about briefly is just some of the steps that you need to take when preparing for an e-trial. And a lot of this is informed. We have an e-trial coming up in early June. So a lot of what we're doing at the moment is preparing for that e-trial and looking to see what needs to be agreed, what needs to be put in place to enable that to go ahead effectively and efficiently. And I think the main difference, or the main thing that people can struggle with in relation to electronic trials and the examination of witnesses over a video conference platform, is what to do with documents and what you do with documentation. Obviously, a lot of civil trials now are very document heavy, and traditionally what's done is lever arch files, and witnesses are given the file and the judge has a file and everybody else has a large volume of paper in a file, and everybody looks to the page when the witness is taken to the correct document. The way to deal with that in a virtual platform is to operate by way of e-bundles, so that there is just an electronic bundle, and these e-trial platforms are very good at making it easy for counsel to take all parties to the arbitration to not just a document, but a section of a document, so that everybody is looking at the same thing as the witness is being taken to that document. And the benefit of that is that it can then link into online live transcripts that can automatically link to documents that are referred to. In the arbitration that we're preparing for, we have also been speaking about hard copy bundles and making sure that we have hard copy bundles available for witnesses. But that does present a number of issues, not least the confidentiality, integrity of those bundles if you're posting them out to witnesses at their home addresses, but also other practical issues. As I think we would all appreciate, it is not unheard of for there to be late additions to the bundles for trial, and quite often that can happen midway through the hearing. If we're all sitting in court or sitting in an arbitral hearing, it's easy enough to slot something in with a divider to the binder. That's not possible if you've got a hard copy bundle in a witness's house, the arbitrator is somewhere else, everybody else in a different location. So an electronic bundle would allow that to be done immediately and just added into the process in the same way as you would if you were all there sitting in a room. So I think if you are looking at hard copy bundles in relation to virtual arbitration or an e-trial, those should really only be there as a fallback. I'm really not persuaded by the benefits of still trying to operate with hard copy bundles if you're dealing with an online platform. I think I've also mentioned there witness access to documents, and I think it is important that when looking at a platform that the witness has the ability, when they're being taken to a document, to independently navigate their way through that document, so that they're not being given a section out of context, so that they have some control. If there's an earlier email in a chain or something like that, the witness can navigate or take the tribunal to a particular section in a document that they're referred to in order to ensure that they're being cross-examined fairly. That takes me on to other witness issues. I think some of the things that we've been speaking about are about ensuring that there is proper integrity of the documentation, making sure that there's no interference with the witness while they're giving evidence, making sure that if they're working from a hard copy bundle, that there are no annotations, that they've not made any notes, and agreeing a protocol between the parties about how you deal with that. And one of the things that we've been speaking about in our hearing is having the hard copy bundle as a fallback, but then having that in a sealed envelope, and that if there is reference to be made to the hard copy bundle, that is opened in front of the camera, and that a warranty is given that that's the first time that that bundle has actually been opened. But these are just some of the sort of slightly more different practical issues that you might have to think about. Another one is time difference. We have a hearing which is supposed to be going ahead remotely in September. Our client is Australian based. The other parties are UK based. So you do have to have some consideration or some kind of fairness in relation to the timings of the hearings, because I think we would all appreciate that being cross-examined can be difficult at the best of times. But if our client was being cross-examined at 4 o'clock in the morning his time, it's unlikely to be a fair way of giving due weight and giving him the proper opportunity to be heard in the hearing. Final point I would make in relation to practical issues just relates to trial prep, and particularly how counsel prepare for cross-examination. Counsel tend to be creatures of habit. They some council prefer working with paper bundles. Some council have very established ways of working where lots of notes are made in pen. They like the hard copy bundles. They like to work that way. Unfortunately, council are just going to have to find a way to work with the new system. You can still make notes. Those notes can be there. A lot of use of multiple screens can enable notes to be available on a screen that's just accessible to you. But we just have to adapt because these cases have to be heard and the technology is there. I think the key, though, if you can, is to make sure that you're working with one of these platforms from quite an early stage so that you can establish good working practices and some familiarity with the document management system. The final point I would make on this is communications with council during the hearing. The equivalent of kind of whispering in council's ear or just tapping them on the shoulder during a particularly exciting piece of cross-examination. Now, a lot of these platforms have got the means to private message other people in the team, but I think there is a bit of a concern with that you may accidentally share a private communication with other parties to the arbitration. So certainly what we've been doing and what I know others are doing is setting up separate WhatsApp groups between council, clients, if that's helpful, so that these points can be shared on what is a private messaging service that's got no link to the arbitration platform at all, and therefore that the other party hasn't got any access to anything that's been said. And just moving on to my final slide, really the question that's posed at the end here, and it's linked to what Jared was saying as well, are we moving into a new reality where actually e-trials are the preferred option? I think I'll probably be in a better place to answer that once we've actually done one in June, but I can certainly see the benefits. I think certainly in relation to giving witnesses a fair hearing, I can see that a witness may well be more relaxed if they're being cross-examined over a video conferencing platform from their own home. The situation that we put witnesses in, where they have to go into a completely alien environment, they're then subject to quite intensive and aggressive cross-examination, and we then make assessments about whether they're telling the truth based on how they reacted to that quite alien environment. I'm not sure that you necessarily do always see the best of witnesses in that sort of situation. Some witnesses thrive on it, some witnesses struggle, but I'm not sure that automatically means that one is more credible or is telling the truth better than the other. Time and cost savings, there will definitely be time and cost savings operating under an e-trial platform. The amount of time that's wasted hanging around waiting for hearings to take place, if we're operating more remotely, you will definitely get those benefits. I think initially the experience in England and with arbitrations has been that more time has been built into evidential hearings, but I think I would say that I think that is down to a lack of familiarity with the processes and with the platforms and building in some contingency to make sure that the hearing's complete. But I think one of the major reasons why we will see more of this is I think it actually makes life easier for arbitrators and judges. If you're working with real-time transcription, if the documents that are being referred to are being automatically linked and cross-referenced in that transcription, then that is going to make life much more simple for arbitrators and judges who are just not going to have to take notes or note things down in the same way. And I can see that being a major driver for change in this environment. But so I think these things I think are here to stay. And it would be helpful and useful, I think, for all of us to take the time to get familiar and comfortable with these new ways of working. And that's all for me. To hand back to Stephen now just to deal with any questions.
Okay, thank you very much, Iain. Thank you to you all for your insights into what's going on. We have 150 people in the litigation team at Brodie's, and they're currently all working from home. So we haven't furloughed anyone, and we've managed to keep people reasonably busy throughout that. There are pockets of high activity in there as well as we prepare for cases, and there's a number of things come out of this discussion. There are questions that this is the bit I enjoy. I can now pose these questions to the panel of experts that we have here. Tony, this is one for you. I think it's actually like a general preparation question in relation to procedure more than anything else. How can you prepare to meet court deadlines, say in the commercial court, if you need to lodge witness statements and the witnesses are furloughed? How can you do that just now?
Well, that's an interesting question because it's one that we've been discussing closely with our employment partners, because the current guidance on furloughed employees is they must not undertake work on behalf of their employer. And because this is guidance from HMRC, it's difficult to know whether they would interpret, say, if you're acting on behalf of the employer and you're approaching a furloughed employee, whether that would constitute work. Now, there's no financial gain in terms of the employer's normal business, but it would be wise in the current circumstances to seek advice before approaching a furloughed employee to find out whether or not they would give a statement. So there are things to be thought through. I would be surprised if a court ultimately would consider that giving a statement is carrying out work for an employer. But of course, we're not dealing with the court in the first instance. We're dealing with HMRC, and they may take a different view.
Okay, thanks, Tony. Jamie, I think this is one for you. Have you got any examples at Brodie's where we've managed to get new actions up and running during the lockdown period?
Yeah, we've seen a number of examples throughout the litigation and our family teams. Certainly one that comes to mind is not long after the lockdown announcement, we managed to obtain a warrant in a case that was going to time bar quite imminently, and that involved working with the courts to ensure the warrant was granted, and then working with messengers and sheriff officers thereafter to ensure that the action could be served within the time bar. Also heard from our colleagues in the family law department, where they've been dealing with urgent cases relating to child protection issues and parental rights and responsibilities. I think the key thing is that the courts are open, we're open, and where there is scope, or where there is an urgent application that needs to be made, such as urgent interim interdicts, it can be done.
Okay, good stuff, thank you. Tony, there's a few questions here for you, I think, and maybe interlinked with Jared as well. Let's start with Jared. Jared, what are the main learning points for the Scottish courts from the English experience, do you think?
I think the main thing that the Scottish courts can take away from the English courts and the relative success that England and Wales has had is that there really is no magic to keeping the court system running, and there's no inherent particular reason why England should have fared better than Scotland in the way it has. Granted, in the e-filing arena, England is slightly further down the road than Scotland, but in terms of keeping hearings running, the English courts have been just taking a pragmatic approach using technology that's readily available. Some courts have been using Skype, some have been using Zoom. So I think the difference has really been one of attitude, and without wanting to be critical, because obviously this is a very challenging situation, I think the Scottish courts have just been more cautious in their approach, whereas in England, I think there has been a general direction that the show must go on, and the courts have found pragmatic ways to make that happen. And I'm sure that if the same approach had been taken in Scotland, the courts would have fared just as well.
I think, Tony, just following up on that one for you, because you're in with the Law Society Working Group for interaction with the court system.
Indeed.
Well, what does the future look like for Scottish courts?
Well, I could start with a bit of background. I also sit in the Information Communication Technology Committee of the Civil Justice Council in Scotland, and we're actually liaising with the English courts as to what they were doing to move towards the delivery of a digital justice strategy. The distinct difference between England and Scotland is that what England did is that it closed quite a number of its courts and then sold the real estate off, which raised just short of £1 billion, which was then devoted to developing their digital capability. Scotland didn't have, although it shut a number of sheriff courts, it didn't have the same injection of capital to do that and had to work off existing budgets. And indeed, if you look at the digital justice strategy that's been published in Scotland, there's one 5 years ago, one just last year, it's all about saving money and not putting additional money into the pot. So there are certain limits as to what could be done to develop that. But certainly what's coming in the future is the simple procedure portal was opened about a year ago, which allowed the online filing of simple procedure actions. Now, the Achilles heel, of course, is they have to progress to ultimately, if they're challenged, to a hearing before a judge. That's what nobody quite anticipated might not be possible. But that portal system is something that will foreshadow what's going to happen in the Court of Session and the rest of the Sheriff Courts. That's the aim. The current crisis has highlighted, as I said at the start, that this is a service, not a place that we're talking about. And consequently, I'm sure that the Scottish courts, within budgetary constraints, will build in the ability to operate as the English courts are doing as they go forward.
I played devil's advocate with that for a second, Tony. You mentioned access to justice at the top of your presentation, and you also mentioned Professor Susskind, and he's quite vocal about the need for us to move to remote courts and virtual courts. And of course, one of the arguments that always comes back at you about that is access to justice, in particular for certain demographics that may not have access to the technology that big law firms and even businesses have. So how do you tackle that issue about access to justice?
Well, that's something that's been looked at quite closely, and most people have, of course, a smartphone or an iPhone. So most of the platforms that have been developed are designed to be able to work with tablets and smartphones. That obviously increases access to justice, but there are some people, my mother's 92, she doesn't have either of those. How do they access it if they want to be party litigants? Well, there still has to be the ability to physically access a building. In the current situation, I would say that it's ought to be possible to access portions of the building, or to access web view capability, perhaps in a citizens advice bureau. I mean, as Jared said at his presentations, there's 159 or thereby court buildings that are still operating and open to the public. We could do that in Scotland. It just takes the will, the effort, the planning to do that, and I believe that's the phase that the Scottish Courts and Tribunal Service is planning for the reopening, or the phased reopening of court buildings.
Okay, thank you. And Jared, here's a question for you. Just before I come on to it, I can certainly contrast this with the Scottish position, but we'll allow you to answer this question first. In England and Wales, are they hearing heritable and debt actions? And as a follow-up, are evictions being granted?
Okay. So I'll take evictions first, just because that at the moment is less a question of access to courts and more relating to the applicable legislation in England and Wales. So currently, all eviction actions are on hold. Certainly, I think it is until the 22nd of June. And as I say, that is not so much an issue of access to courts. It's about government not wanting people turfed out of properties in circumstances where the rental market is currently frozen. So there are no evictions currently being granted. As for heritable and debt actions, you have to, I think, draw a distinction here between actions brought before the onset of the lockdown and those brought afterwards. If an action has been commenced before the onset of the lockdown, that would be treated as ordinary non-urgent business, which means that certainly if you had a hearing of that kind of action scheduled for during the lockdown, I would expect that the court would reach out to the parties to make a proposal for a virtual hearing, so there's no reason why that shouldn't go ahead. In terms of new actions, again, there is no reason why a new action could not be brought at the moment. As for how that would be progressed in the lockdown, as I mentioned in my presentation, what is far less clear at the moment is how quickly new cases will move. The courts have done a very good job in keeping existing hearings in the diary and going ahead wherever possible. But in a new debt action, assuming it is disputed, that is a case that you would expect to take a period of months in any event, by which time we might be out of lockdown. But certainly, if the lockdown were to extend over a lengthy period, I don't see any reason why an action for enforcement of a debt would not move through the courts in the usual way, albeit it's very, very difficult to see how that would be treated as urgent business that the courts would actually prioritise.
Okay, well, the position in Scotland is that I think at the last count there were in the region of 17 to 18,000 cases in the Sheriff Court which are classed as debt recovery actions. And of course, one of the things that happened quite quickly was that all these hearings from round about March through to August in some courts were immediately discharged and then all placed in the non-urgent category. Apart from anything else, the regulators have weighed in here. So if you're regulated by the FCA, for example, or Ofwat and these sort of people, then there has pretty much been, universal tolerance measures applied to various sectors. So even if you wanted to raise an action, the regulators are kind of saying to the people that they regulate that they shouldn't really be doing that, just they should be granting tolerance and forbearance measures. Iain, I've got a really good question for you here. Is this the death knell for commercial litigation in the Scottish courts?
I think it's probably too early to say that. We've got a lot of affection for the commercial court particularly, and I think, Stephen, I'm pretty sure you had a proof that was being fixed by the commercial court that was going to be fixed for June if those dates had suited. So you're kind of assuming if the commercial court in Scotland was doing something like that, that there must have been a plan to have that hearing proceed by way of some kind of virtual platform. I think what you have seen though, like I said in my bit of the presentation, is the benefit of something like arbitration where you control the process, you're in charge, you've developed, and there's a bit more flexibility. Arbitration just able to be an awful lot more reactive. The English courts have been quicker at being reactive than the Scottish courts have been, but I still hold out hope that the Scottish courts will be able to adapt and will be able to find a way to enable evidential hearings to go ahead. As Jared said, the technology is there, and it's just a case of, the stuff is, you could do it yourself. It's really not that difficult to operate, and it just requires minimal training and a bit of patience. And there's no reason why the Scottish courts couldn't be operating exactly the same way as the English courts are.
Okay, and a follow-up that I think you could help with as well, Iain, but also Tony could maybe weigh in on this one. Is there particular e-bundle software platforms or software which is acceptable to the Scottish courts?
We had a big trial that ran in the Scottish courts, and we used, it was Opus, Magnum Opus, which is sort of live transcription and e-bundle and document management. So for bigger proofs in the Scottish courts, they've already adopted and been using kind of e-bundle platforms and live transcription. And these guys offer, it's not a huge step up from that. All you're building or bolting onto that is a video conference platform. So it's using, something like Skype for Business or Zoom combined with, one of these kind of e-bundle platforms that the Scottish courts have been quite comfortable to work with in the context of evidential hearings, in-person evidential hearings anyway. So I've not encountered any resistance, particularly where the parties have had a conversation and agreed it to any particular e-bundle software platform. And in fact, they've been quite receptive to it, because, in a lot of ways, it actually makes life easier for the judges.
I would echo that. The Scottish courts didn't set a particular type of e-bundle that they wanted. They did have at least one presentation from a provider who was showing what they could do, and it was very capable bundling Adobe documents. But I indicated to them that in one case where we had to do that, was a very large construction case. The bundle had cost £40,000 to put together. Which concentrated minds. So the court didn't set a particular software package because they didn't want to deny access to justice to people who couldn't afford the significant costs of what you might incur in some of the larger cases with particular types of software bundling. So they're as Iain said, they're quite tolerant of the type of bundle, but really what parties have to do is get together and agree how it's going to be done.
Okay, thank you. And Iain, this is one for you, I think, because clearly there's a desire in a public court system to ensure that the public still have access to hearings, and there's a whole paragraph on that probably that could follow from Tony. But concerns on privacy and data from the platforms you're using for arbitration, how are you combating that?
Yeah, it is something that you have to consider. I think the way that we've approached it, because obviously arbitration hearings are confidential, So you're not going to be live streaming them or doing any of the things that you've seen the High Court doing in England to ensure that the public have access to bigger trials that are running there. Usually the approach that's taken is that you have a third party controls access to the video conference platform. So there is a, similar to access to webinars and things, there's a waiting room system, and it requires an operator to actually allow somebody access into the platform. And we've kind of got around any issues on the part of the party. So it's not one of the parties that's hosting this. It's being hosted by the tribunal itself. And the tribunal itself is controlling access to the actual tribunal hearing, and also allowing kind of breakout space effectively for the different parties, so private kind of breakout sub-video conferences as well. So I think the key is really having somebody operate an invite-only system for the video conference platform, and then that party controlling access to the hearing itself through that platform. So it can be done.
Okay, thanks. And this is for you, Tony. Just in context, the Tayside in-court advice project is still available, but there is no direction from the courts to the service or mention on the website. So it would seem that the website could direct court users to the in-court advice services who can advise and assist with dispute resolution. Is there any reason why they can't be directed to those services on the website, which in turn would assist the court at this point in time?
It's a good point, because you may remember that I noted that there was no indication from the Scottish Court's website as to how members of the public could access hearings, and it would appear that there's some updating of the website that's required overall as to how people access those things that are available. So I'll be raising that later.
Okay, thanks, Tony. And we're nearing the end of the questions here. A couple on arbitration. Iain, there's a question just about the main advantages of arbitration against litigation in the current health crisis context and generally when normal trading resumes. Could you maybe just distill that down to what you see as being the three main advantages of arbitration over litigation at this point in time?
Sure. I think it reflects what I've been saying already. I think the flexibility of the process is a major one. It's just you can innovate, you can adapt. You're not tied to specific rules in the same way. You're not tied to physical buildings in the same way. So that allows, hearings, the approach to hearings can pivot very quickly, assuming that you've got a kind of cooperative counterparty. On the other side, having just come off 4 weeks of arguing with the other party in a litigation about what the appropriate platform was, I can't say that's always straightforward, but it should be relatively straightforward if you've got somebody who is relatively cooperative on the other side and a proactive tribunal. Efficiency is the other one. I think that arbitrations, I'm not going to try and say that arbitrations are any cheaper. In fact, sometimes they can be more expensive, but there is a clear driver on the part of the arbitrator to push the case through to a hearing and actually have the case resolved in a way that you don't see the similar kind of impetus coming from typical court actions. There is a real imperative to push through to a hearing, and that's what we saw with arbitrators really driving the adoption of e-trial platforms. And finally, the major positive arbitration, which isn't a COVID thing, it is confidentiality. You ask most parties, they're not going to want their cases heard in open court. So the fact that it is a confidential process, even if there is an appeal, it's a confidential process, is and always has been a major benefit of arbitration.
Okay, well, thank you. We have no further questions on the Q&A function, but I think that when we reflect on where we are now, if you were to say to us, 3 months ago, that we would have solicitor advocates engaged in remote debates at Inverness Sheriff Courts, I think you all would have said, don't be daft. But that's where we are now. And I think that what we've got here is a huge opportunity for really effective reform. This virus is continuing. It's a health crisis that we're still grappling with. When we do get it under control, who's to say that we don't end up in the same situation in a year's time? So I think that necessity really is the mother of all invention and innovation here. And we would be really pleased if you would be able to just send in to us. We're going to put you onto the last slide, which is the contacts page here. We're pleased to kind of gather in views from clients, other professionals. You'll note here that the key contact slide, this is when we all had access to hair, makeup and beauty. But we're all looking a bit rougher now, a bit shaggier in the hair for some of us. But just wanted to say thank you for joining us. If you do have any queries, keep them coming in. I'm going to end the meeting and we'll leave the meeting. But if you do have any queries, put them into the Q&A function and we will try to come back to you after the session over the next few days. So thank you for joining us and let's see how we get on with the court system going forward through the rest of the crisis.
Thank you.
Thanks.